I'm Victoria from Bright Horizons.
And I'm Jennifer from Bright Horizons, and welcome to our series of videos on IEP and special education topics. Today we're going to be talking about discipline rights for children on IEPs.
Basically, a child on an IEP can be suspended, just as other children can, but there is a limit on days. At 10 days suspension in the school year, the school has to do what is called a manifestation determination, where they would have a meeting to determine if the behaviors were a manifestation of the child's disability or not. And basically, that would be like if a child, it would not be a manifestation if a child has, say, a learning disability in reading and the behavior that got them suspended was something like fighting with another child or a teacher. And at that point, they would have the manifestation to determine the cause of that, and then they would do what's called a functional behavior assessment and come up with a behavior plan if needed.
Basically, one of the things to know when they're looking at whether or not the behavior is a function of the child's disability, that's very important because it impacts how long a child can be disciplined for something. As Victoria said earlier, a student on an IEP can be suspended up to 10 days without the school doing an FBA and a manifestation, but really it's good practice if a child is consistently having difficulties to do it sooner. Because the whole idea is if the behavior is in fact related to the disability that the child is on an IEP for, the goal should not be to punish them and get them out of school, but to look at how can we revise the IEP to help the behavior not continue to occur, what other supports need to be in place for the child. And when we talk about the 10 days, we mean 10 days throughout the entire course of the school year, so not just 10 consecutive days. So if your child has been removed 2 days here and 3 days here and 3 days here, then you're getting up to a problem, at which point we should probably be looking at a manifestation. Another thing to know is that 10 days removal does include any time the school asks you to pick up your child and take them home because they're having a hard day or something like that. That's something that as advocates we always advise. As a parent, you need to ask the school to document that as a suspension so that it goes on the list of 10 days that they're allowed to do. We've had many cases where schools will over and over say, well, we just set it up for mom to bring the child home because we didn't want it to be on his record, and they put that forth as a nice thing to do. But what it also keeps them from is the legal obligation of how many days you're allowed to suspend a child on a disability. To let people know in general, if your child does have a more serious offense involving drugs, weapons, or serious bodily injury, and serious bodily injury really does mean that somebody needed to seek medical treatment. It doesn't mean maybe they got pinched or their glasses got thrown or something like that. Those are cases where a child with a disability can be suspended for up to 45 days or moved into what's called an interim alternative emergency placement. And that's something where if it's drugs, weapons, or serious bodily injury, the school can at that point change the placement without the parent's permission per se. That really doesn't happen very often. It does happen sometimes, but it doesn't happen very often. But even if the school does want to do that, you as the parent have a right to file a due process to fight against that change in placement if you don't feel that that was appropriate. But again, that really only comes up in cases of drugs, weapons, or serious bodily injury. Most of the time, when you hear the word expulsion related to kids with disabilities, everybody tends to freak out and think, my child is being kicked out of school for the rest of the year. That's not the case. What an expulsion actually means is your child is being put out of school for some time, more than 10 days, and only up to the 45. It's only if the manifestation is determined not to be related to the disability that the school can impose the penalties they would on a child without a disability and many times those things can go up to 90 or 180 days, so you really don't want that to happen. But I would say, honestly, most of the time, if the child being suspended already happens to qualify for an IEP under a disability category that's related to behavior, we as advocates would say that the school would be pretty hard pressed to make a case that the behavior is not related to the disability.